We always at this event deal with important themes and developments in administrative law, and as I reflect on what is happening, the concept of accountability seems to me to be central to the discussions that we will be having. The courts and the executive continue to struggle with the central themes of administrative law, the appropriate oversight of administrative decision makers, the requisite degree of independence, and the protection of individual rights in a fair and cost-effective manner. Excuse me. Our first panel will look at the issue of tribunal independence in the context of increasing executive control of decision makers through accountability documents, as reflected in legislation both in Ontario and Alberta, as well as through the appointments process. We'll turn then to Chris Brett, who is going to review legislative and case law updates, where we will see an increasing trend to deference by the courts, and in the Conway decision, a truly expanded charter jurisdiction, which raises many challenges for administrative decision makers. Professor Chapman will join us to focus on the duty to give reasons, certainly in an evolving area in administrative law, and a central element in accountability to the public as well as to the courts. Following that, the eternal issue of access to information and protection of privacy. We'll be joined by Paul Chavis and David Goodis, who will review the jurisprudence in this area and discuss the critical accountability issues for government agencies in this age of information. I will then be speaking on regulatory negligence, which is a tort law issue rather than an administrative law issue, but I will be addressing regulatory negligence as an element of accountability for substandard administrative action through tort lawsuits for damages, and more importantly, what the potential for regulatory negligence means for administrative agencies and decision makers in the design of their governance and accountability documents, their statements, websites, policies. And we'll wrap up the day with a discussion on administrative monetary penalties, an expanding tool in the regulatory arsenal. When we talk about $1 million administrative money penalties, we're talking about a big expansion of those tools. We'll look at the appropriate role of large penalties in an adjudicative framework. Throughout the day, I hope that you will have questions. I think it's important for us to have a dialogue, and what best informs the speakers and what helps you get most out of it is to ask questions and to actually engage with us as we all collectively learn and discuss these pressing issues.